Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories, and after that we can delve into the full details. The Supreme Court today closed Habeas Corpus petition against Sadhguru's Isha Yoga Center and said that proceedings cannot be to malign institutions. Supreme Court has granted bail to Uttar Pradesh MLA Abbas Ansari in a case over alleged unauthorized jail meetings and threats to witnesses. Aam Aadmi Party leader Satyendar Jain has been granted bail today in a money laundering case. The Supreme Court is set to launch live streaming of regular hearings in all benches. The top court has stayed Punjab and Haryana High Court order which stopped trial of Dera Sacha Sauda chief Gurmeet Rahim in the 2015 Sacrilege cases. In the Rajasthan Civil Judge Exam 2024 case, the Supreme Court has today issued notice and sought production of English essay papers with low scores. The Supreme Court has suggested ban on child betrothals, saying that marriage is fixed during minority of child violates free choice. The Apex Court has recalled its judgment which struck down Section 3 and 5 of the Benami Transactions Prohibition Act 1988. The Supreme Court has imposed a cost of 1 lakh rupees on the state of Jharkhand for filing a frivolous SLP. The Supreme Court has today closed the habeas corpus petition filed by a father alleging that his two daughters were being allegedly confined at Sadhguru's Isha Yoga Center at Coimbatore. The petitions were closed because of the categorical statements made by the two women, who are presently aged 42 and 39 years, that they were staying at the ashram out of their free choice. While closing the matter, the Supreme Court bench comprising CJI Chandrachud, Justices J.B. Pardiwala and Manoj Mishra took exception to the Madras High Court passing directions for police inquiry on other allegations against the Isha Yoga Center in the petition. It said that since both of the monks here are adults and the purpose of habeas corpus was fulfilled, no further directions were needed from the High Court. Earlier this month, the Supreme Court had transferred this matter to itself from the Madras High Court after Isha Foundation challenged the High Court order to conduct an inquiry inside the ashram of 5,000 residents. At the last hearing, after interacting with the two monks itself, the court restrained the Tamil Nadu police from conducting any further inquiry and had asked the police to submit a status report to it. The same report was also submitted, wherein the court has been informed that in the last few years, some missing persons complaints and inquiry on suicides relating to the Isha Yoga Center have been filed. The police also stated that the alleged detainees in the ongoing habeas corpus case have been living at the center as per their free will. Further, the report mentions that the Internal Complaints Committee under the POSH Act is not functioning properly and a notice has been served into that effect. It also mentions the pending cases against members of the foundation. Senior advocate Siddharth Luthra, representing the state of Tamil Nadu, today asked the court to clarify that closing the habeas corpus petition would not stop the police from investigating the ongoing cases. However, senior advocate Mukul Rohtagi, appearing for the foundation, opposed this, arguing that such a statement could be misused to target the institution. Solicitor General Tushar Mehta also supported Rohtagi's claim. The court then recorded in its order that the decision only addressed the habeas corpus petition and that issue was now closed. In the next update, the Supreme Court today granted bail to Uttar Pradesh MLA Abbas Ansari in a money laundering case and in another case involving allegations that his wife made unrestricted visits to him in Chitrakoot jail and he used her mobile phone to threaten witnesses and officials. With respect to the second case, a bench of Justices Suryakant and Ujjal Bhuya, while granting bail, noted that the investigation was complete and Abbas had been in custody for more than 1.5 years. Further, without expressing any opinion on the merits of the allegations and keeping in view that conclusion of trial will take some reasonable time, he has been granted bail on the condition that he will fully cooperate with the trial proceedings. The counsel for the state today said that Ansari's wife was caught carrying 2 mobile phones inside the jail, which he used to threaten witnesses and officials. He requested for a direction to Ansari and his wife to reveal the passcode to the mobile phones, as the forensic department had not been able to access them. To this, the bench conveyed that Ansari should cooperate to the extent law requires. Another bench of Justices M.M. Sundaresh and Pankaj Mithal granted him bail in a PMLA case. As per the Enforcement Directorate, Ansari used 2 firms to launder money. He was booked under PMLA and was arrested in November 2022. ED alleges that a partnership firm named Vikas Construction was the prime vehicle that Ansari used to commit scheduled offences and generate the proceeds of crime. The court, while granting bail in this matter, did not make any observation on the merits. In another important update, a Delhi court has today granted bail to Aam Aadmi Party leader Satyendar Jain in a money laundering case. He was arrested by the Enforcement Directorate in May 2022. The Supreme Court had granted him interim bail in May last year on medical grounds. And in March this year, he returned to Delhi's Tihar jail after the top court denied him regular bail. Jain, let me tell you, is the third Aam Aadmi Party leader who has been granted bail in different cases in recent times. Former Delhi Chief Minister Arvind Kejriwal was granted bail last month, while his former deputy Manish Sisodia was granted bail in August in the alleged Delhi liquor policy scam. While granting bail to Jain today, Special Judge Vishal Gogne of the Rouse Avenue courts observed that considering the delay in trial and long incarceration of 18 months and the fact that the trial will take a long time to start, Jain was favourably suited for the relief. And now let me tell you, the Supreme Court is proposing to start the live streaming of regular hearings on all benches. The proceedings of all benches of the Supreme Court were streamed live today. The streaming was done on the court's own application instead of its official YouTube channel. The official launch of this live streaming is yet to happen. Currently, only Constitution bench matters and hearings of public importance have been live streamed. Recently, if you remember, the 3-judge bench hearings in NEET UG matter and the RG Kar suo moto case were also live streamed, considering the public interest. In the 2018 landmark judgment in Swapnil Tripathi versus Supreme Court of India, the top court had opened doors for virtual access to the courtroom proceedings. The court issued directions of live streaming of cases of constitutional and national importance, barring those involving juveniles, cases of sexual assault and matrimonial issues. Like the Supreme Court, High Courts too are live streaming court proceedings, with Gujarat High Court being the first ever High Court to do the same. The Apex Court has put a stay on an order of the Punjab and Haryana High Court, which stayed trial of Dera Sacha Sauda chief Gurmeet Rahim in 2015 cases relating to sacrilege of the holy book Sri Guru Granth Sahib. The controversy is around a series of sacrilege incidents in Punjab starting in June 2015 with the theft of the Guru Granth Sahib from a Gurdwara in Faridkot. Later, sacrilegious posters appeared and torn pages of the holy book were found in October, sparkling massive protests. During the protests, police opened fire on the protesters, killing 2 people and causing further unrest in the state. 12 people were named in the related cases, and the investigation was initially handed over to the CBI, which filed a closure report in the year 2019. However, both the ruling Congress party and the opposition Shiromani Akali Dal rejected the report, leading to the Punjab government withdrawing consent given to the CBI. The cases were then transferred to a state police SIT, which named Dera Sacha Sauda leader Gurmeet Rahim Singh as the key conspirator in this matter. In 2023, the Supreme Court ordered the trial to be shifted from Faridkot to Chandigarh. This year in March, the High Court put a stay on the matter while referring a question of law to a larger bench. The question was whether consent given by the state government for a CBI probe can be withdrawn later. Against this order, State of Punjab approached the Supreme Court. And today, the bench of Justices B.R. Gawai and K.V. Vishwanathan issued notice and stayed the impugned order of the High Court. The Supreme Court today issued notice on another petition challenging Rajasthan Civil Judge Cadre 2024 exam on the ground that its evaluation process was arbitrary and flawed. The petition has been filed by 96 candidates who undertook the exam. They allege that after the results of the main examination were released, their scorecards revealed extremely low marks between 0 and 15, specifically in the English essay paper. This irregular scoring contrasts with their otherwise strong performances, leaving them unable to reach the interview cutoff. They argue that the subjective evaluation of essay writing combined with no minimum qualifying mark for language papers has led to arbitrary results affecting their fundamental rights and careers. Today, a bench led by CJI Chandrachud issued notice and directed the production of those answer sheets where candidates have been marked below 15 marks for English essays. Earlier, the CJI had orally remarked that the court would reverse the process if any irregularities were found, regardless of completion of the interviews. In another update, the Supreme Court has suggested to the Parliament to consider outlawing child betrothals by amending the Prevention of Child Marriage Act 2006. Since that act does not deal with child betrothals, the court noted that it can be used to evade the penalties under the act. This is in a judgment delivered by the bench led by CJI Chandrachud in a PIL filed by Society for Enlightenment and Voluntary Action seeking steps to stop child marriages. The court has observed that marriages fixed in the minority of a child have the effect of violating free choice, autonomy, agency, and childhood. It takes away from them their choice of life partner before they mature and form the ability to assert agency. The court also noted that international treaties like the Convention on Elimination of All Forms of Discrimination Against Women stipulate against child betrothals. Also, the court refrained from deciding the issue whether Prevention of Child Marriage Act 2006 overrides personal laws which sanction such marriages. It noted that Parliament is seized of the issue since 2021 when a bill was introduced to amend the Act to give it an overriding effect over personal laws, and the bill is still pending. The Supreme Court has today recalled its 2022 judgment in Union of India versus Ganpati Dealcom Private Limited, which struck down sections 3 and 5 of Benami Transactions Prohibition Act 1988 as unconstitutional. A bench comprising CJI Chandrachud and Justices J.B. Pardiwala and Manoj Mishra recalled the judgment, allowing a review petition filed by the Union government against this judgment. The bench noted that constitutionality of the provisions of unamended Benami Transactions Act was never raised in the original proceedings. The only question which was framed by the bench, which originally heard the matter, was whether prohibition of Benami Property Transactions Act 1988 as amended by the Act of 2016 has a prospective effect. However, the bench in its conclusion held that provisions, that is section 3 and 5 of the unamended Act, were unconstitutional. Therefore, allowing the review petition, the court recalled the judgment and restored the civil appeal for fresh adjudication by a bench. And lastly, the Supreme Court has today imposed an exemplary cost of 1 lakh on the state of Jharkhand for filing a frivolous special leave petition. In this case, the petitioner worked at a primary health center and was transferred to a new role in Garhwa. However, he wasn't relieved from his current position, which prevented him from joining the new office. This led to his suspension and eventually dismissal. He approached the High Court arguing that his dismissal was unfair with no reasons given. The state, on the other hand, argued that he was found guilty of 12 out of 14 charges. The High Court held that dismissal order was a non-speaking one and deprived the petitioner of his right to appeal. The High Court cancelled the dismissal and ruled that he was entitled to pension benefits, though reinstatement was not possible since he had already retired. Against this, the Jharkhand government appealed to the top court. A bench of Justices B.R. Gawai and K.V. Vishwanathan recalled that it has repeatedly insisted against filing of frivolous SLPs by the state governments in the last 6 months, but the issue continues to persist. Thus, taking a strong stand, it imposed the cost. Also, to recover the cost, the court granted state the liberty to initiate an inquiry against the officer responsible for advising the filing of an ill-advised SLP. For more details on the cases that I mentioned, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.